that the plea be withdrawn. State, have you had a chance to review the defense counsel's motion?
We have, Judge, and we are ready.
All right, and State, are you in agreement with the defense's motion or no?
We are not, Judge. We are opposed.
All right, defense, you may
Yeah,
proceed.
Judge, just and so the record's clear, his previous attorney filed, Mr. Douglas Campbell filed the motion to withdraw as counsel and the motion to withdraw his plea simultaneously. So the motion before the court includes both. So the court is aware. So I came on board, just so the record's clear, I came on board after the motion to withdraw the plea was already filed.
Yes.
So on behalf of my client, I'll call him as a witness for the purposes of this.
All right, could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Arnold Pena.
All right, you may proceed.
Thank you, Judge. Mr. Pena, what, the things I spoke to the court about regarding when you and I met, was that factually correct?
Yes, ma'am.
And I did not represent you in any capacity up until the day that Mr. Campbell withdrew as your lawyer and filed the motion to withdraw the plea on your behalf. Is that correct?
Yes, sir.
Now, since then, you and I have had a chance to meet a couple of times and we've discussed the motion and we've looked at discovering some of those things as well. Is that correct?
Yes, sir.
Now, the motion that Mr. Campbell filed on your behalf, one of the things it alleges is that you had some questions or you lacked the understanding of the viability of a self-defense claim. Is that correct?
Yes, sir.
So tell the court a little bit about, did you know that you could have possibly used self-defense?
Yeah.
But was it explained to you that you would have a trial? Was I the first person to explain to you, you would have a trial and that instruction would be given as to self-defense and what effect that could have on the jury trial?
And Judge, if I may, I'm going to object. We're getting into things that are privileged by attorney-client privilege, and that has not been waived as of yet by the defendant.
You want to, are you okay to waive that privilege you and I have and discuss what the discussions you and I've had regarding the self-defense issue? No? Okay. Now, well, then you just tell the court on your behalf why you believe Mr. Campbell didn't inform you properly and what other things you think Mr. Campbell did that affected your inability to understand the plea you were entering into.
And Judge, I'm again going to object. We're getting into things that are privileged by attorney-client privilege.
Mr. Campbell is no longer your attorney. Will you waive that privilege? You can answer those questions.
Yes.
All right. You
Go
may
ahead.
proceed.
At first,
Well, here's the thing. I want you to listen specifically to the question that Mr. Bonk is asking you. And that's the question that you need to answer. Do you understand?
yes, ma'am.
And what I can tell you, based upon this motion, there are potential allegations in it that relieves Mr. Campbell of his confidentiality with client. You understand? All right, so listen to the question that's being asked by Mr. Bonk. And the only thing the court is focused on at this point is the self-defense issue that is being raised or potentially raised by this attorney with the questions. Do you understand? All right, Mr. Bonk, you may ask your question.
Without talking about what you and I spoke about, did you and I discuss self-defense and how self-defense was applicable in cases like yours?
Yes.
Okay. Now, go backwards to the conversations you had with your prior attorney and tell the court what discussions, if any, you had about self-defense with Mr. Campbell and what your understandings were after those discussions.
We really didn't discuss much of the self-defense. The only thing that he brought up to my attention was if I signed on the 25 cap.
Okay, so here's the thing. You need to speak up because the court reporter can't hear. I can't hear.
I'm sorry. He didn't bring up much of the self-defense. When he talked about the the 25 cap, yeah, told me if I sign on the 25 cap, when we go to the jury trial, they can't go above the 25 cap.
So but in fact, in this case, you entered a plea, is that correct?
Yes.
And the 25 cap you're discussing, that was the deal that you and Mr. Campbell worked out with the state to avoid having to have a trial. Was that your understanding?
Yes,
So you understand that if the court today was to deny your motion to withdraw your plea, then the plea bargain that you entered into is what goes into effect today. Okay. Now, regarding self-defense, you said earlier a few minutes ago, you know what self-defense is from a layperson's position, correct?
yes,
And I've asked you if you and I discussed it in a trial, and the strategy of a trial, without going into what we discussed, and did we discuss that?
yeah.
And was that the same or different from the conversations you and Mr. Campbell had about your rights to raise self-defense if you had a trial, or what that would entail?
Completely different.
Tell us how so. Tell us regarding your conversation with Mr. Campbell, not your conversations with me.
Bare minimum, he didn't even bring up the self-defense. He really just avoided the situation pretty much.
Okay, some other things that are raised in this motion is that specifically talks about the fact who the aggressor was, what in your opinion, based on your having been there, what you thought was reasonable, who the aggressor was, and those types of things. Did you and Mr. Campbell discuss all of that?
No,
Okay. Now, once again, without talking about what you and I talked about, did you and I have a chance to go through all the evidence
yes,
and videos and those types of things?
yes, and
And compare or contrast, or was that the same evidence that you saw with Mr. Campbell?
no,
Okay. Part of the motion also, he's basically says that you're claiming on your behalf that, and once again, I didn't file this, you're claiming, or Mr. Campbell on your behalf says, there's different, the self-defense allegation, potentially ineffective assistance of counsel. Do you know what that means?
no,
And okay, ineffective assistance of counsel is when you're telling the judge, that your lawyer didn't do the job he should have done, that type of thing. And the motion seems to indicate that that's something you're concerned about. What do you want the judge to know about that? Because I certainly wasn't part of any of that.
he, the fact that he wasn't really doing his part, I would call my wife to set up visits with him, and he wouldn't really set up any visits. I would talk about my discovery. He wouldn't really show much of my discovery. He had said that there was 3 videos, but he only ended up showing me 2. The fact that he has also said that there was 96 videos of the highway case. I don't think that he really saw all 96 videos on my behalf.
Now, regarding the plea itself, do you remember the day you entered the plea?
Not exactly.
And from my reading the record, this honorable judge was not the individual, I don't think, that took your plea. Do you remember if it was this judge or if it was a different judge?
The one that signed on the plea, no.
You know,
No.
okay.
It wasn't the group.
It wasn't this judge, okay. Now, on that day, did Mr. Campbell go over the plea paperwork with you? The stuff that you signed and then the judge showed you at the time of the plea?
Yes.
Remember, typically the judge says, hey, is this your signature? And you say yes or no.
Mhm.
And did you in fact sign the papers that you and Mr. Campbell went over?
Yes.
And did that judge ask you at that time whether or not you were entering this plea freely and voluntarily? And what was your answer to that? Yes, you were. So what has changed between that day and today to where you think, the plea, you should be allowed to withdraw your plea?
The self-defense.
And specifically the self-defense. And that's, as I understand it, you're saying you didn't understand the the manner which it could be used in your defense, and the way a jury could get instructions during a trial and those types of things. Is that correct?
Yes.
Is there anything else you want the judge to know about your experiences with Mr. Campbell? Because I don't know anything about it, that you think she should know before she makes this decision.
I don't know. Okay.
Okay. Now, the state, I think, is going to try to play some jail phone calls where at some point you talked to some family members and said, hey, you might try to use self-defense. You remember that?
I would have to hear it.
Okay, but does that sound like something you may have said?
Maybe.
Okay. And once again, that goes back to that you knew that self-defense was a real thing. You just didn't know legally how it could be applied to your case. Is that correct?
Yes, sir.
Okay. So when you spoke to your family members on the phone, you weren't making any legal decisions or you were just saying, hey, I think that maybe this, in your opinion, based on the facts, that might be something that would be beneficial to you at some point.
Yes.
Is that correct? Okay. Then Judge, that's all I have at this point.
All right. Any questions?
Yes, Judge, a few. So, Mr. Pena, how many times did you meet with Mr. Campbell while you were client?
Less than a handful of times.
Okay. If you had to put a number to it,
I would say like 3,
3 times?
4 times. Maybe.
Okay. Three or 4
I would say 3.
around there. Okay. Let me ask you, Mr. Campbell, what is your understanding of self-defense?
I mean, Mr.
Mr.
Pena.
I'm sorry, Mr. Pena. Yeah. What is your understanding of self-defense?
If someone's the aggressor, I could defend myself at any cost.
Okay. So basically, if someone's like, let's say I'm coming at you with a knife or I got a gun and I'm pointing it at you, you're allowed to defend yourself, right?
Yes.
Okay. How long were you in jail?
About to hit my 9 months.
Okay. Were you in the main jail or the annex?
Main jail.
Okay. What floor is the law library on?
Can't really say,
Let me ask, did you ever go to the law library?
they don't let us go to the library.
They don't let y'all go. Are you aware that that's a violation of a couple of laws by the Bexar County Sheriff's Office? So you sure you're not allowed to go to the law library?
I've never been to it.
Okay. But you have, from what you were saying, it sounds like you have a common idea of like what self-defense is.
Yeah.
Okay. Would it surprise you if that's pretty much, besides a few nuances, that's pretty on point with what the penal code says in Texas Penal Code 9.01? Okay. So you do have an understanding of self-defense. Okay. And when you were talking to Mr. Campbell, I believe you just testified that he glossed over self-defense, kind of avoid the situation.
Yes, sir.
Did not talk about it entirely.
Yes.
So he didn't speak about self-defense at all.
Not really.
Okay. Mr. Pena. So we're on the record. You've been sworn to tell the truth here. So I'm gonna ask you again. You did not ever speak to Mr. Campbell about self-defense before January 6th, 2026.
They came up one time, that's about it.
So now it did come up. Okay. I'll pass witness judgment. Wait, hold on. Judge, I would ask that you take judicial notice of the court's file.
Any objection?
No.
And what specifically are you asking me to take notice of?
The court admonishment and defender's waiver and affidavit admonishments.
All right, so the court will take judicial notice of that,
Okay,
and the court has the plea paperwork.
okay.
All right.
And I'm gonna ask. Well, I believe it's a 601.
Okay.
Okay. Judge, I'm showing to the defendant for the record what's been labeled as state exhibit number 1. Mr. Pena, can you tell me what this is?
I just thought it was- I feel,
Okay, I'm sorry, you need to speak up.
my case,
Yeah, is this a copy of the paperwork that you signed when you took the plea?
Yeah.
Okay, let's look on the page that is defendant's waivers and affidavit admonishments. Now, on the next page, there's a signature there. Can you tell me who signed that?
No.
Okay. And that's saying that I've had my constitutional legal rights explained to me by my attorney, and I have decided to waive my constitutional right to trial by jury and enter this plea before a judge. Did you agree to that?
Mm.
I have not been threatened, coerced, or placed in fear by any person to induce me to enter my plea. You agree to that?
Mhm.
I understand the court's admonishments and as contained in this waiver. You agree to that? I am satisfied with the advice and representation of my attorney in this case. You signed for that, you agree to that,
Yeah.
right? What's the date on the signature?
The 5th, January 5th.
January, looks like a 6. January 6th, is that about right? Okay.
Highlight that, the highlight. You highlighted all that. The original's not highlighted.
The real is not highlighted, no.
All right, any other questions?
Judge, I'd like to play 2 jail calls that are contained in state exhibit number 2, unless there is any objection by defense.
Yes, I object.
Judge,
Well, he can refresh his memory with the jail call, so before, it's not being offered before the court, but if he's gonna say that he doesn't remember what he said on the jail call, it can be played for him.
All right, so what is, ask him the question, then see if he remembers. If he doesn't, then he can hear the jail call.
okay. Mr. Pena, do you remember making a jail call on October 14th, 2025?
I make a lot of phone calls.
Okay, so you did make phone calls that day.
I make a lot of phone calls.
Okay. Do you remember talking to someone about self-defense that day?
I don't recall.
Okay. What about on December 12th, or I'm sorry, December 2nd, 2025? Do you remember making the jail call that day?
Like I said, I make a lot of phone calls.
Okay. You don't remember talking to anyone about self-defense that day?
No, I have to remember,
Okay.
I have to remember, read, at least listen to the phone call.
Okay. So if you listen to these, they would refresh your memory?
Yes, sir.
Okay.
All right,
Judge,
so
like,
but before we do that, is anyone planning on calling Attorney Doug Campbell?
we plan to call him for our case, Judge.
Are you planning on calling
In
him?
my case, no.
Yes. All right, so because Mr. Campbell is here,
I'm gonna go out of order. I don't mind.
yes, let's go out of order because the court is going to be taking a recess at 12:30.
Of course, Judge.
All right. So defense, you have no objection to going out of order?
No, not at all, Judge.
All right, state, who are you calling?
Judge, we'll call Mr. Campbell.
All right, Mr. Campbell? Hi.
Oh.
All right, can you raise your right hand? You're an officer of the court, but I'll swear you in. Do you solemnly swear or affirm that you will give true testimony?
I do.
All right, you can lower your hand, state your name for the record.
Doug Campbell.
State.
Mr. Campbell, how long have you been a licensed attorney in the state of Texas?
Right at 25 years.
Right around how many clients do you think you've represented in your time?
All right, is she excused?
She is excused by the.
All right, thank you.
Purpose of the record, I'll be playing the first call dated October 14th, 2025, starting at 6:09. When I got indicted, when I called you about making indicted. I got the court date, I'm gonna put lawyer been submitted like there's an act court on Friday. I think I was like a Monday or Tuesday, yeah, I came and visited me on the video. And if I go with all the court did, don't say you were talking to me about the court. Because as of right now, there's just one, self-defense, then I. Judge, I'll be playing the second call. That is dated December 2nd, 2025.
Then you, right, there's been before, the thing at the movie. It's like, no, you got. You might.
No, baby, don't worry about it, my love. I mean, no, so if anything, like this, my lawyer was telling me that he's got 96 videos that he's got to watch. And he's so far, he's seen 6. So hopefully by now, he's already seen all of them. And he can come up with something, you know what I mean? And what I told him was,
Wait, so then, what was he gonna try to do then?
well, I'm seeing self-defense. So if everything worked out the way I said, like, I only told him one story, and it hasn't changed. And it's gonna match up to what happened. Other than
What
that,
that,
his story, he's already changed like twice. You know what I mean? He's gone from, I was recording a self-defense, I was recording a road rage, to, I was in the road rage. So these stories are not matching up. And if everything works out, like I said, I mean, like I told I asked my lawyers, if they haven't given me an offer, is that good? It's like, actually, it's okay. I can't say it's good, and I can't say it's bad, because some people will give them an offer, to like, hey, well, you are, you did the crime, you gotta do the time. And I say, yeah, but I did self-defense, I was protecting myself. Because I know if everything, the way you told me your story, and it matched.
Judge, may I ask a few more questions of Mr. Pena?
Sure.
Mr. Pena, for a third time now, after hearing those jail calls, do you still continue to believe and state that you did not have any meetings with Mr. Campbell about self-defense, nor any awareness of self-defense?
That's not really what I said on the video, on the recording.
Clarify for me then. What did you say?
That I'm keen self-defense. Not that he talked about it.
So you're saying you're going to plead to something that you weren't aware of?
I have some idea of what self-defense is. That's why I kept saying that I wanted to.
Arnold Pena walked into that courtroom asking a judge to undo a guilty plea. His argument was straightforward. His prior attorney, a man named Doug Campbell, had failed him, failed to explain self-defense, failed to show him the evidence, failed to prepare him for what entering that plea actually meant. And for a moment, just a moment, the story seemed like it might hold together. But the law has a way of catching up with people, and in this case, it caught up through Arnold Pena's own voice. 2 jail calls, made months before the plea, were played in open court. In both of them, Pena can be heard discussing self-defense after meeting with his lawyer. The calls directly contradicted what he had just testified to under oath, and when the prosecutor asked him to explain, the story he had built started to fall apart one sentence at a time. The judge in this case did not rush to judgment. She reserved her ruling, saying she needed to review the calls more carefully before deciding whether the plea would be withdrawn. What she was really doing was giving the record exactly what it needed: a clean, careful, documented decision that cannot be easily challenged later. Doug Campbell, the attorney at the center of the accusation, took the stand himself. 25 years of practice, multiple discussions of self-defense, a law partner who also sat with Pena, a thorough handling of the evidence by any measure according to his own account. The question this case leaves open is whether Arnold Pena genuinely didn't understand what he was pleading to, or whether he understood it very well and simply changed his mind. The jail calls suggest an answer. The judge will have the final word. If you found this case as eye-opening as we did, hit that like button, drop your thoughts in the comments, and subscribe for more real courtroom breakdowns, because justice never gets old.